Well, I intend this to be actually kind of, in some ways, more of a discussion than a talk, but I've got like roughly an hour or so planned of a couple of different main topics to talk about. But part of the reason why I agreed or wanted to do this was to actually get input from technologists on this issue. Because I spend a lot of time talking to lawyers about AI. Most lawyers don't know very much about AI at all. And so I like to talk to people who know a fair amount about AI and technical developments, so that way I can help sort of translate some of those issues and concerns for lawyers.
And if the crowd's feeling shy, Drew, I tend to be pretty good at prompting things that may spark conversation, so we'll be fine. The meetups predate me being even on the board, much less board president. I've been managing the meetups probably going on 9 years now. But the organization, as you will hear shortly, dates back to the early 90s. I was not around at the time.
What was your background? Technology. Development engineer? Or? Yeah, that's basic. Healthcare. What investment? Media data processing, distribution.
So anybody here actually work on any AI technologies? Like as part of your normal job? As a startup?
Several capacities. I have worked with AI since Google in 2007, but more recently my work has been focused on medtech, clinical applications, as well as some research collaborations with a group back in DC on policy and governance.
Mm-hmm. So that's where we thought we would see all the breakthroughs, is that AI went through all the different permutations of proteins and found the thing that will cure cancer, right? Why hasn't that happened?
I mean, when it comes to protein folding, I speak as a former bioengineer, it has been quite remarkable in solving the protein folding problem, though we're not all the way there yet. That's a very hard problem. But I mean, so I work in medical tech now, and so most of the people floating, should we do AI with this thing, has mostly been me being, no, the risk is way too high.
AlphaFold is very impressive. It's like a different class of problems. You have something complicated happening, but once you get the result, you know it's right.
Right.
So, like folding stuff, you can fold and fold and fold, and they're like, yep, it fits. So you have an easy check. And complexity comes in. We want to apply AI to problems we don't have an easy way to check an answer. And then we find out, okay, you gave me a wrong answer.
Yeah, I mean, a good example I give in medical tech is a place where I would be for it is, say you have a patient with 20,000 pages, essentially enabling kind of semantic search so that when you control F, it doesn't just literally find the exact words you typed, it might find a bunch of related phrases in the document in terms of meaning as well. That's safe because it gets it wrong, well, you can just see the words literally not there. But in terms of trying to then diagnose disease, that's well, if it hallucinates, the consequences could be dire. And it doesn't matter how many warning messages you put up telling the doctor you have to check this, it could be wrong. They won't, not always.
The robot they used for hernia surgery on me 3 months ago, a month before that, they just enabled AI on it.
And how's your hernia?
I mean, getting your guts rearranged is unpleasant, but I'm fine now. They put fishing wire all basically between my growing belly button, but we're not here to talk about that. But the doc said, hey, your insides are now being used to train AI. Congratulations. To which I responded, is it on the consent form? Before I finished the question, I said, no, it wasn't. Go bring it up at the hospital.
That is it, because one of the things we'll be talking about is the copyright lawsuits over training AI models and everything, and whether or not the use of copyrighted material for just training purposes, if that constitutes a direct infringement of the copyright. But it's whether or not that use of your body, internal body scans
Yeah, I can certainly, I've been working with so much medical data, and yeah, like under HIPAA, whether a patient opts into the data being shared, if it makes you feel any better, these networks take it extremely seriously. They will absolutely kick companies off these networks with even a whiff of impropriety, actually. I've seen it firsthand, actually. Not to say there isn't shenanigans, there's corruption everywhere. I could tell you fun stuff about people weaponizing HIPAA to entrench their monopoly and not actually empower the patient. Let's see. We're going to start.
If you're asking question issues pertaining to open source models and ways.
I'll talk a little bit about that, but I haven't. That's not an area. Well, I was pretty familiar with open source, licensing stuff. I was an IP lawyer and everything like that, but I don't know, for example, like the difference between like Meta's approach, where we're going totally open source versus OpenAI's approach, for example.
At all.
But not that many open source models. There's some open ways, 3 or 4.
Open ways, yeah.
Yeah, which is a huge difference.
Sure.
I'm very happy at doing that.
Well, that's a good point. But the question I keep getting asked is, basically comes down to fair use and sufficient modification in order to, claim it's fair game for commercialization or whatever.
This is again reading a little bit in the weeds, but the Supreme Court last year actually had a new opinion on fair use that basically said, look, if you're getting a lot of financial benefit out of this, even if you're transforming it, but you're basically, you're selling this new transformed version of a copyrighted work, even a lot of cases that would in the past be considered to be fair use because they transformed it a lot, right? That's new and everything. Now the people are sort of saying under the new Supreme Court precedent, a lot of that would not be held to be fair use because they're now making a commercial use out of it. It's something that they would have otherwise been able to license.
Is that the context of an application of software or what?
This was in the context, the Supreme Court case was in the context of an Andy Warhol painting.
Oh,
So-
that one, okay.
so-
All right, I know what you're talking about now. Gotcha. Okay.
So for the rest of you, basically, Andy Warhol there was some photo, right? And Andy Warhol said, all right, I'm going to turn this into an Andy Warhol painting. He just basically took the photo, right? And I don't know if he maybe did a little bit of things with it or whatever, but he's like, all right, this is now an original Andy Warhol piece. And he argued that I transformed it. I went through the whole Andy Warhol this process or whatever, and now it's a completely different work. It's fair use of the original photo. And he was obviously selling this new work of art. And the person who took the photos sued him. And initially the court held, yeah, that seems like he transformed it in doing his art style or whatever. And the Supreme Court said, no, that's not sufficient to be fair use.
Almost like the guy who was such a good illustrator who was able to take a $1 bill or $5 bill and make it look, basically copy it by using his hand. And people in coffee shops would see him do this and say, hey, pay me with that instead of regular cash. And the Secret Service didn't like that because he started doing it all around town.
There's some of the thing with Wozniak, is you could get original print runs of $2 bills and they're legit. You have to pay more than face value for them. And it's you go and you just cut a $2 bill off the sheet and it looks super sketchy, but they're legal tenders. Yeah.
Hey Drew, you ready to get going?
Sure.
I think we got more than enough people. We can go ahead and get
Sure,
started.
sure.
So yeah, I basically do my usual little intro spiel and then I turn it over to you. All right, welcome everyone to the latest monthly installment of the EFF Austin Meetup. My name is Kevin Welch. I'm the current president of the board at EFF Austin. I see old and new faces. Welcome all. To those of you who are new and what's EFF Austin? Well, EFF Austin is an Austin-based digital civil liberties organization. We closely work with Electronic Frontier Foundation based out of San Francisco. They're the nation's oldest and largest digital civil liberties advocacy firm. You can kind of think of them as the ACLU for the internet. They want to protect your rights in emerging technological spaces. That's no problem. I hope you're okay. They work to protect your rights in emerging technological spaces, especially your First Amendment right to free expression and your implicit Fourth Amendment right to privacy. So yeah, they're really awesome people. They fight about a lot of hot button issues around technology policy. You've heard in the news, protecting things like net neutrality, end-to-end encryption, Section 230 of the CDA, right to repair, a whole bunch of awesome stuff that give you as a citizen the right to use technology to empower yourself and not how a government or corporation thinks you should be using it. So they're really awesome people. They've been around since 1990. We are almost as old as them. We've been around since 1991. I was not present at the time. But yes, we're actually the oldest member of what is called the EFA, or the Electronic Frontier Alliance, which is a group of about 100 digital celebrities groups all around the United States. None of us are formally legally affiliated with EFF. It's not a chapters-based organization. There were plans for it to be. That's another story. But none of us have formal legal affiliation. It's kind of peer-to-peer activism. They mostly work at the federal level. Most of the other groups do city and state activism. And for a long time, EFF also was not only the only EFA group in Austin, we were the only one in Texas, though I'm very happy to announce that our fellow Austin friends at Open Austin are also now members of the EFA. So we're very excited to welcome them because they are awesome people. And actually, that leans into, the main thing we do is educational. We have meetups every month, the second Tuesday of every month at 7 p.m. here at Capitol Factory. And we have several fun ones coming up over the next several months. Speaking of Open Austin, the current head of their board, Liani, is going to be coming and talking to us about Open Austin and all the cool stuff here in this town they do about civic activism and stuff. So just a little kind of intro to our fellow EFA member. Also going to be hearing from our board member, David Hensley, in October, who's going to be talking about data cooperatives. We have somebody booked for November. Can't remember off the top of my head. It's been a crazy day. But you can come chat with me if you're curious about more future programming. You don't want to hold it up too much. Beyond that, we also do, while nowhere near as much as National EFF, we do a bit of legislative work as well. We've been consulting both with the city and state as they are ongoing in their plans to try to figure out AI regulation. Also, probably our biggest policy win recently was at the city level, where we were very involved in the fight around bringing back automated license plate readers. While we were not able to stop the city from bringing them back, we were very proud that we got massively stronger limits on data retention than they originally wanted to do. They originally wanted a whole dang year. We managed in the initial negotiations to get it down to just 30 days, and actually with the new city council, we further lobbied that down to 7 days. And we actually lost by 1 vote, getting it down to 3 minutes, which is the biggest current regret of my activist life. You know, we can try again sometime. Anywho, yeah, we do that. We've also occasionally been known to throw cool cyberpunk parties if eccentric millionaires with means want to throw money at us. Introduce me to any you know. So we're entirely a community-driven organization. You know, we basically do what the community wants us to do. So if you're like, you guys sound cool, but why aren't you doing X? Well, you should volunteer to do X. So we think stopping this yourself. We'd love for you to get involved. So get at with me later. And also after the talk, we'll probably go have a drink at the Omni Bar lobby. So if you'd like to get to know anybody here and chat further, happy to do so. I guess also what I will say is before I introduce our speaker and turn things over to him, I generally like to make a little place for, are there any community announcements? Shameless self-promotion's totally allowed as long as it is somehow vaguely relevant, you think, to the interests of the digital celebrity community. Any other events going on, things you're working on, feel happy to share them. No? Okay.
The Attorney General just settled a lawsuit. The Attorney General sued Meta for use of FRT based on DPS information. Everyone wants a copy of the order. Grab my card, I'll send it to you. It's quite interesting.
I'd be interested in the details of that. Yeah, I actually was contacted by some local news about that story. My basic take was, yeah, on the one hand, good. On the other hand, you know, doesn't change the fact that I feel the politicians involved are not necessarily doing this for altruistic reasons, even if they did the right thing, and it's also kind of too little too late. The damage was done 10 years ago. So, you know, that's how I feel about it. Others may feel differently. So I'm going to introduce our speaker here. Our speaker this month is Drew Harris. I have known Drew for many years through means that maybe we can talk about later at the bar, but keeping it professional right now. Drew is a civil rights trial lawyer with a passion for technology. While at Stanford Law School in 2002, he assisted the Electronic Frontier Foundation through the law school's Cyberlaw Clinic. After working at large law firms on IP litigation cases, he switched to public service in 2010, where he litigates employment cases on behalf of the state of Texas. Drew frequently gives presentations to other lawyers on technology, legal ethics, trial presentation, and employment law issues. For example, Drew published an article on ethical issues raised by lawyers' use of ChatGPT in the Austin Lawyer magazine. Outside of law, Drew is a music festival enthusiast, having attended every South by Southwest and ACL for the past 17 years. As somebody who's friends with him on social media, I can confirm this man likes his live music. So yeah, basically what I reached out to Drew based on some stuff he was posting about in this space is that I realized that one of the really interesting things about generative AI I've not actually seen a lot of people talking about is the impact that it may have on the entire way we conduct trials in this country, specifically with evidence. We literally just the other day had Donald Trump claiming that Kamala's crowds were AI generated. There have already been multiple instances of powerful individuals, I think Musk was one, but probably there's been others, claiming that evidence against them was created by generative AI and they were innocent. Now, regardless of what you think of the merits of any of these individual claims, clearly we are going to more and more be seeing this used as a defense. So I thought it might be very interesting to ask a practicing lawyer the actual implications this is having on how we decide if somebody's guilty or innocent in this country. So yeah, without further ado, take it away, Drew.
All right, thank you very much, Kevin. So yesterday I gave a talk to a room full of lawyers. We gave a presentation on lawyers about legal ethics and generative AI. As lawyers, we regularly have to take continuing legal education, CLEs, every year, and we have an ethics requirement. We're supposed to take at least 3 hours of ethics because that supposedly that ethics training will keep us ethical. But I will say that the issues related to new technology are complicated, in some ways complicated. And so I was giving this presentation to a bunch of lawyers on what you do when you discover your client has fabricated some evidence. Do you have to go to the court and let them know? Like, how do you deal with that as an attorney? And so these are some of the things that, that generative AI are going to make a lot more common. I mean, obviously people have lied and created evidence or destroyed evidence in the past. But now it's really easy to create some documents, and if you have this lawsuit and lots of money or your personal freedoms at stake, maybe it'd be a simple matter of just creating the evidence you need to win that lawsuit. And obviously, if your lawyer finds out about it, we do have an ethical duty to the court, to the whole system, to make sure that they play by fair rules. So that was in part, I've given other similar presentations to lawyers and judges about use of AI. And so part of the reason why, again, I wanted to give this talk and have it be a little bit of a discussion is to also engage with the technologists about these sort of ethical and legal issues related to AI, and kind of hear about, and both communicate to you guys how lawyers are thinking about it and dealing with it, but also to have, and hopefully these concerns, there may be some technological solutions to it. So here's the quick roadmap of my talk. And like I said, feel free to raise your hand and ask a question at whatever point. I have a couple of, like I said, big bullet point issues that I'm going to be talking about. I'm first going to just introduce a little bit about myself and my sort of background in this area. I'm going to be talking about the way that it has directly impacted lawyers, in that some lawyers have literally been sanctioned for using Chat-GPT. So we'll talk about some lawyers' misuse of generative AI and how the courts have handled that already. We'll talk about some common legal issues like intellectual property, these copyright lawsuits that have been filed against OpenAI for training, using copyrighted works for training data. We will talk about confidentiality and trade secret concerns, about how anything you put into ChatGPT, of course, can be used to continue to train it. And we'll talk about deepfakes and defamation and false things created, in terms of the lawsuits related to that. But I will then return to that big central question, which is, how are courts going to deal with all the fake evidence that's going to be so easy to generate with generative AI? And I actually honestly don't know if there is a very simple, easy answer. So that's partly why I wanted to have a dialogue like this. So again, to introduce myself, maybe it might be good to sort of start about my own early connection with EFF. I went to law school at Stanford, and I remember at that time I was really wanting to do intellectual property and high-tech stuff and whatever like that. Even before then, I actually spent some time at Trilogy in the post, the pre-2000 time. So when Trilogy was a nice sort of startup and everything like that. So I had some experience in the technology field. Went to Stanford, was wanting to do technology law, did this whole Cyberlaw Clinic where we worked with the EFF about shrink wrap licenses. Now it's really no longer a disputed legal issue, but back then that was like the hot thing, that you were basically, just by opening software, you were basically agreeing to a contract. And there were a lot of legal questions and debates about that, and so that's one of the early things that EFF was working on at that time. And what's fun is that I got, have any of you heard of a law professor named Lawrence Lessig? Okay, I got him. So he was one of my professors at Stanford. I was his research assistant. He was actually teaching a class called Law in the Virtual World. And as some of you may know, he wrote this very influential book about how there's East Coast code, the laws and statutes that are passed by Washington, D.C., and then he contrasts that with the West Coast code, which was the code of softwares that would, again, also limit behavior. So in other words, you could limit behavior either by passing a law saying you can't kill somebody or whatever, but you can also program, the characters in the video game that they're not able to kill somebody in a virtual world. And so that was an interesting idea, that these problems that we are dealing with can be addressed either through law or through West Coast code, whatever. And so that's why I do think these issues with respect to AI, they're going to have to be dealt with both from West Coast code and East Coast code. I know a little bit about the East Coast code, so I can talk to you about that. I want to hear more from you guys about West Coast code, if you will, about ways that technologists are trying to solve these or address these problems. So, with that kind of said, let's talk about a presentation I gave a little over a year ago. I got to have a presentation with U.S. District Judge Robert Pittman. He's a federal judge here. And we gave a presentation, again, about legal ethics involving AI and about and because a lot of lawyers at that time, over a year ago, they had no idea about using Chat-GPT. And so it was kind of eye-opening for them to talk about how you could basically use it to write your cases. You could write your briefs. But that's not a good idea. Because as you guys probably know, Chat-GPT has hallucinations. Because it is making up stuff. It will make up all sorts of stuff, including fake cases. And so we had some notable examples of lawyers who tried to rely on either Chat-GPT or some other AI to basically write their briefs for them. And they didn't bother to actually double check the case citations, which, that are in their briefs, which did not exist. And so when the judge read it and obviously found out that they were citing made-up cases, hauled them in front and sanctioned them. And it was kind of interesting because you would have thought that that would have been a big faux pas. Anybody guess what was the monetary amount they had to pay for it? Any guesses?
One of them had $10,000, the other was like 6 months suspension from the bar.
So yeah, there's another case,
and
yes.
the license.
But the monetary case was only $5,000.
You can make something up to a judge and only pay a $5,000 fine.
But no, it just cost $5,000 to make something up. You can call it
Obviously,
cost.
these people are also now become somewhat infamous in that, now they are held up to lawyers across the country of what not to do. And people like me will go and warn other lawyers, don't do this, see what happened. There was another lawyer who did it, who again got suspended from the bar, not able to practice law. But in addition to making up the case, the briefs, right? He filed, it was an area of law he apparently didn't know much about. So of course he turned to Chat-GPT. It's here, can you write the brief for me? And it writes a brief and he files it. And he then later realizes, oh wait, those cases that are in the brief are made up. Problem is that when he gets hauled in front of the judge, the first thing he said, oh, my intern like messed it up, you know, blamed it on the intern, and
The
obviously.
Silver Wings defense.
Yes. So he got suspended for 6 months, so a much more severe sanction. So those are just a couple of examples about how lawyers, you know, are basically already like learning that, you know, misusing, you know, chat AI. But I think that's eventually going to get sorted out, because as lawyers, we're supposed to know you double check your work, right? Like that was just stupidity. But there's this bigger issue of whether or not you have to let the court know that you're using AI. So if you write a brief and you use AI, whatever for it, do you need to let the court know? And there's at least one judge in Texas who actually has a standing rule that he actually makes all the lawyers appearing from him to tell him in advance whether or not they are using any AI. They have to file a certification when they appear before him, attesting that either no portion of any filing was drafted by generative AI, like Chat-GPT or whatever, or that they took responsibility and double-checked everything. And he makes two really good fundamental points in his order. One is that, of course, there's a problem about hallucinations, that, you know, it makes up that right now, the current state of technology, it's inherently erroneous. Like there are just errors built into it, unfortunately. And I think that's something that you guys technologists should be able to figure out, right? Like I would imagine that that's something that could be solved by West Coast code at some point. But right now, that's a big problem. Lawyers are getting caught, and so that's one of his reasons. But he has another reason, which is about reliability and bias. Because what comes out from ChatGPT is bias by all the stuff that gets put in. And not knowing how a large language model is trained, you don't know what bias is going into that. And he makes a point about how attorneys who do the work, who draft the briefs and everything, they swear an oath to set aside their personal prejudice, biases, and beliefs to faithfully uphold the law and represent their clients. But generative AI makes no such vow, right? It's literally a cabin to whatever information you plug in to train. So part of the fundamental ideas of why the lawyers, like, again, it's not just a matter of going to law school. There's like a whole bar admission process and a whole swearing in process where you were literally taking an oath to uphold the Constitution and faithfully apply the law. And so if you act unethically, you can be suspended or barred from practice, no longer able to practice law. And so that's just something that obviously, yeah.
Do you want to address the importance, do you want to address the importance of accuracy in filings and briefs? Specifically because some judges, especially at the state level, probably don't know as much law as you do, because the only requirement is that they win the majority vote, be licensed for 4 years, and be a resident of the state of Texas.
Yes.
And so we have to train judges, and I'll get into more of that later on the story about metadata, which is a discovery issue. So that, and then second question, 5 years from now, it's going to be embedded in everything we do. So that certification is just going to be something.
I mean, it's already been built into the newest version of Microsoft Office.
Right.
Like Microsoft Office Copilot already now has AI, built in. So I am wondering, like, literally every lawyer who appears in front of this judge who uses the newest version of Microsoft Office is going to have to say, actually, we are using it, but yet we promise we will double check everything. So yeah.
To elaborate a bit more, I'm not sure why does the court dictate which tools are used to prepare the document. And to simplify, could the court say you can only submit documents that are written with a black pen?
So there actually, believe it or not, are rules like to the font, to the how big the font is, to the margins.
It would be like dictating that you use Microsoft Word versus Open Office. It's the same PDF to the same standards, whatever.
Yeah, back there?
So this is probably pedantic, but how would you honestly answer that question? So for instance, let's say you tell ChatGPT, write this section of my brief, you check the box. But if you have, let's say, 10 different cases that are 1,000 pages long, you upload one and you say, do you think this case has anything in it that supports what I'm saying? Here's what I said, here's this case. It goes, no, here's why. And then it says, no, here's why. And then it goes, yes, this one does. And I say, where is it? Page 967, second paragraph. And I'm like, oh, okay, this supports what I said. So you can use Chat-GPT and say, write this for me. But you could also use it like Google or like a research assistant. So at what point do you draw the line? And if that's the case, like, how would you answer that question?
So that is the big, again, initial problem about, we're talking about how judges and lawyers are trying to deal with generative AI. This one judge had the bright idea of just saying, you don't, if you're going to use AI, you need to like disclose that or whatever. But as you pointed out, that question becomes a lot more difficult.
Like, does use mean right, or does use mean I'm asking you a question on, if I ask that question, what font size am I supposed to use on this? Does that mean that I used it if I wrote the whole thing myself?
It's when you substitute your judgment or skill in producing language instead of conducting, because that's conducting legal research just on that instead of actually.
I can provide a little context, and this draft is already public, so I'm not disseminating anything I can't, but this is literally some of the stuff that the city internally is trying to figure out with city employees, and what are the lines between when they can essentially use generative AI as research or aiding them in working faster versus what is the line, okay, if you're sending it out now in an official email, okay, you need to actually draft that yourself. I think these are those lines they're trying to figure out where it lies.
So let's say with Google, if you do a search, it'll show you a result from Google Books or the library. Like this is on page 964, and it's similar to what you type. So that's the kind of thing that Chat-GPT can do. And it's intending itself to do a prescription.
But like I said, the basic point is that I think judges are trying to struggle with it. And this initial approach of just simply saying, lawyers don't use it, or lawyers, you need to like disclose that you're using it, I think is going to be a difficult strategy to do that when it's embedded in everything, or you can use it partially. But let me tell you, yeah, go on.
My model of the legal field would be that like, they wouldn't care like how the sausage was made, but like.
Well, I told you, there's two reasons though. There's two reasons that the judge gave why.
The rule would be like, once you submit it, it's treated exactly as if it came from your own mouth. That's how I imagine the legal. So
Take responsibility.
right.
Yeah.
Right.
So it's like, it doesn't matter if it came from error or not. If it has an error, then it's as if you, the lawyer, made that error.
But the difference though is that if you screw up as a lawyer, someone could literally go to the death chamber if you make a mistake. If you file, it'll give you a point. Even ChatGPT 4, and I've asked it to write a writ of habeas corpus, and every time it does, with millions of examples, and this is the one fatal flaw. It doesn't tell you to attach an affidavit to the writ. It doesn't give you a writ, or it doesn't give you the affidavit. And if you don't have an affidavit attached to a writ, guess what happens?
It gets rejected.
Yeah, rejected automatically. Done. In federal, you get one shot for a writ.
I think your point there is that like ChatGPT or not is a tool. It does not replace what you
It does, but
It doesn't change liability.
it doesn't change liability, but it's one thing to say, you as a lawyer are responsible for the words on the ink and the PDF that's filed. It's the other thing for you as a judge to make sure that all the parties before you are being properly represented by competent counsel. And if counsel is using something that's not competent, hallucinating.
It's the same status as something that came from like an intern or something. The lawyer still has to read it over and say, is this valid? And then submit it.
Right, yeah, they do. But what's more likely to hallucinate, the intern or ChatGPT?
It shouldn't
An
matter.
intern's going to give you a real
everything to make
case
sure
that's wrong. ChatGPT is going to give you a case that doesn't exist at all, it never has.
Sure, and that's a lawyer's responsibility to check that before they submit it, and they should be held responsible. My model of the legal system is that we treat them the same, regardless of whether they're blaming the AI or the intern or their own goof up.
Yeah.
Seems like in litigation detail.
Do what?
Seems like in litigation detail,
Uh-huh.
so we can maybe tackle it, as to how the document was created, whether using ChatGPT or not. Once it's submitted, you don't really know, should you care how it was done. It needs to be up to the standard. I think.
Well, again, the point is the judges are literally calling the lawyers into court and asking them to explain exactly how they wrote that brief and how they came up with this case that doesn't exist.
And the Fifth Circuit makes you swear that you wrote it, that an intern didn't write it. So when you're doing the appellate level above the district court, so you're going to the Fifth Circuit, or
That is a surprise.
they are making you say, I swear that I did this and the intern didn't, or the paralegal didn't, that I drafted this.
This still violates, I don't want to get too much on tangent, but still violates my model of like the legal, whatever, industry or whatever, that I thought the rule would be like, use all the interns you want, but like, you've got to review it and validate it and then submit it. It just seems strange that they would have a rule that like, you can't have interns like helping you and you just make the changes and then submit it yourself.
Well, you can. You
But
totally.
then that's what you're saying right here, is that an intern didn't write it.
You have to, on Fifth Circuit briefs, you have to, sort of the bottom of it.
Okay, I think we might be getting a little bit.
But I do appreciate that we have a lawyer and technologist with very different views on the issue, which is, I think, what we were hoping. We get some broad perspective.
But let me give you an example of where AI was apparently clearly doing too much. There was this AI company called Do Not Pay that has all these like forms, and they would auto fill out forms for you. And last year they had this big like marketing thing where like, we're gonna have the first robot lawyer for somebody in traffic court. They were gonna have that little earpiece, and it was in real time supposedly going to tell the person what to say to get their ticket dismissed. Okay? So they made this big splashy announcement, and apparently they immediately got threatened with imprisonment for unauthorized practice of law. Because if you were literally telling people what to do in court, that's, a lawyer saying, and kind of like the idea is that lawyers are supposed to be trained and have this responsibility and this oath and everything, so that way if we are advising you where you might go to jail, we have that, that training and whatever. And if you're just using some technology, some program, AI program to replace the lawyer, whatever, then that would be an unauthorized practice of law. There is this question of, well, maybe that's not bad. Because after all, the most recent version of Chat-GPT apparently does better on the bar exam than like 90% of lawyers.
I actually have a fun sidebar to that. I dug more into that story. The programming was a little skeptical. It turned out it only does that well if you feed it the test questions in advance. Just like a human who's seen the test before they take it, you do pretty well on it. The performance, I think, dropped something staggering to like 20% without essentially getting to cheat.
So anyway, but this is a sort of question about what, at what point are you relying on a program to tell you what to do legally speaking? And I think right now, the status of both the law and I think general, people is that they don't really just trust a program when your rights and your imprisonment and your liberties are on the line. So that's one area I wanted to talk about. Let's move on to the fun copyright stuff. This is actually probably one of the most well-known lawsuits involving ChatGPT, is that several different authors have sued OpenAI alleging copyright violations. And what's interesting is that there's these two cluster of lawsuits. On the West Coast, in the Northern District of California, which is like where San Francisco is, there's apparently a group of authors who are trying to form a class action saying that, hey, you've used my copyrighted works to train ChatGPT, and therefore that is a violation of my copyright. I think it's actually one of the lead plaintiffs is Sarah Silverman, among others. And then in New York, there's another set of lawsuits, another class action being filed, and that one, among the various other potential plaintiffs in it, I think the New York Times notably was one of the ones suing because, again, they basically fed all the New York Times articles into ChatGPT to help, train it, and obviously they're alleging that's a violation. These lawsuits are still going on, and they're going to go on for quite some time. I don't know if we're going to get a definitive answer anytime soon of whether or not that's legal. The main update is that there were various theories that were done, and one of the theories that was advanced was, hey, when you put all this stuff into ChatGPT, all the stuff that comes out was based on our work, and so therefore everything that comes out is basically a copy of my work. And that argument, that theory of that derivative work, that got rejected. So that claim is like, no, that doesn't make sense. But the claim that simply using copyrighted work for the purpose of training a large language model to get the accurate results, that is an economic use of somebody's work. That is not fair use. That's literally taking, again, if it were like a textbook, you could sell a textbook, right? And if you just take a textbook and we're going to feed it into the computer, how is that any different than the purpose of buying a textbook?
So I'm curious, so we had another big tech lawyer in here a few months ago who actually argued persuasively that training is fair use. And I'm curious how you'd respond to his key argument that training is not creative expression, it is a statement of fact, because at the end of the day, it is just representing statistical properties of the training data, and you can't copyright math.
Mhm. So if it were just adding like the periodic table or basic math or basic, stuff, I don't think that, you're right, that would not be a copyright violation because you can't have a copyright on that. But when you are writing articles for the New York Times and you are expressing complicated ideas about the news and, and summarizing that, and therefore the Chat-GPT is using that to figure out what the news and what the facts are, you've now taken something that was a creative work that was intended to educate somebody, and you were expected to be paid for that, and now you're saying we're just going to take it and give it to, feed it into ChatGPT and not pay you for it.
I'm actually really tempted to maybe at some point have you and Ed have a nice little debate on this topic. How would you also respond to, how is training any way different than a really sped up version of a human being going into an art gallery?
Well, let's just pretend it's a human being, okay?
Real quick, I still think there might be a slight confusion. So Ed's argument wasn't that the information being fed into the data set was the factual information that cannot be copyrighted. It's literally the statistical information, like this number of sentences begin with the letter A, this number of sentences in this thing begins with the letter B, et cetera, et cetera, et cetera. Like, those are the statistical pieces of information, the direct observation of the article itself, not the facts being conveyed by the article.
Right, that's actually worse, because for example, a bunch of believe it or not, a telephone book can be copyrighted, even though it's just a bunch of factual information. It's a bunch of names and phone numbers, right? Just raw facts, but it's organized. It had some sort of human element that made some sort of sense and structure to it. It alphabetized it, organized it, it did it in a way that made it usable. And the Supreme Court has held that is created, protected expression, and if you are copying that, you have committed copyright infringement.
It's funny because Ed actually did talk about how map makers would put their own little thing on it to protect their copyright, etc. I think though Ed was arguing that, but they didn't make a map, they essentially have a recipe for making a map, and that's just based on the map, the statistics of the original. So they're not still copying the creative expression.
Well then why would they need to put in the New York Times stuff? Why wouldn't they just put in a bunch of text and a bunch of
this ties into what I was about to
they don't, the final model doesn't contain the New York text. It
Right.
contains a statistical model of all possible text that can be generated from the data set.
And I think this ties, I promise this is relevant, I think it ties into another point I was making where he kept asking us, how is what the model's doing factually any different than a human artist wandering through a museum and looking at a bunch of paintings and from that learning themselves how to paint in similar styles?
That is
Scale.
Well, yes, and I admittedly argued that that's why ALPRs are problematic, even though the police are not technically not doing it except in a public space. I've argued the scale is what makes that problematic, so that's a fair counterpoint.
So I think that this idea that you're taking this information, you're using it to train, that is an economic benefit, that is an economic gain, if you will, that OpenAI is getting. It now has a smarter large language model.
Yeah. Contrast it with what Compaq did in the 80s. They reverse engineered the...
they figured it out by themselves instead of,
Right.
Yeah, so again, I think the example he's doing is that there were some early or fair use reverse engineering cases that basically said, if you copy a computer piecemeal or whatever like that, that might be copying, right? But if you are just simply taking it apart and figuring out, oh, you need to have red wires connecting to red wires, or whatever stupid example, right? And then you build another computer that has red wires connecting to red wires, you're not copying it, you're literally just learning about what the facts are and then building it yourself. And so that's held to be...
It's so funny because that's essentially what Ed argued large language models do. I really do want an album meetup where the two of you talk. I love that you both have very different takes on this. I love it.
I can jump in this. It could be like, I read a bunch of horror novels, I reverse engineer what makes a good horror novel. Maybe a bit of a stretch, but...
To point out one thing real quick, I think the answer to your proposition is that the difference is the human paid for the ticket to that gallery in that museum, right? My question to you is, what difference would it make if OpenAI, say, paid that $19 retail price tag for that book, or that $50 subscription to the New York Times?
I could be smart and say there's a free museum day, but fine, my taxes paid for it indirectly.
How many times does it actually read the article?
So isn't OpenAI paying millions of dollars to Reddit? So that way it can take all the Reddit's content?
Well, they're forced to do that because Reddit paywalled the API precisely to stop ChatGPT from scraping.
They could scrape if they wanted to, it's just not important.
Well, they'd have to do paid scraping, which is compared to an API.
It'd be like going to the bookstore and just reading off the shelf versus they kick you out if you do that too much, you buy the book.
Yeah. So again, that is the theory, like, which is like, you're right, that if you had legal access to a book and you reverse engineered yourself what it was, but you still had to get access to that book. And what the lawsuits are saying is that OpenAI was not paying for access to the New York Times' information.
Yeah, is that, Ed mentioned the thing that's still up in the air, he said, was the interim copy between the original scraping and the final training. So is that related to the interim copy problem?
He was basically saying that, before they can feed it into the model, even if the model at the end of the day doesn't contain any of the copyrighted information, they still had to save it in a buffer somewhere before they fed it into the model to train it, basically.
But how can you say it doesn't contain it if it knows what word is next?
Well, because it just statistically knows that word usually comes after that word, so it's just guessing.
It definitely does not, I can confirm, it definitely does not contain the original text.
I've done enough into the linear algebra. I know
Tell me the war and peace, and it spits out the entire novel.
Yes, I would.
That is definitely contained.
I recommend a really good way of trying to understand this thing is looking up this thing called the Library of Babel, which is based off of Umberto Eco story about an infinite
It's
library.
actually Borges.
Oh, sorry. Okay. Sorry, I knew it was some Spanish guys. Are they Spanish?
Yeah,
So that goes Italian. So I got a little extra.
Romance linguist. So yeah, but there's this website called the Library of Babel where it uses a hash to generate any possible text, and then it will tell you the specific like building and bookshelf and book that this text is contained in. So you could go to the website and you could feed in a piece of text and just say, yeah, it could be anything. It could just be like, hey, my name is so-and-so and I'm doing this today. This is the weather outside. And you could feed that in and it would then tell you this information. And then if you took this information and went through clicking through all these hyperlinks of this like model, link-based model of like this thing, you would eventually find the page with that piece of text on it. And you could go hypothetically to any of these pages anytime you want, and you might find some sensible text. Most of it's nonsense because it's all just like a hash, basically. Yeah. It's a way of generating text from a seed. But
The joke of the short story is every work of Shakespeare's in there somewhere, but you'll never find it.
yes, exactly. Which is like literally, if you got very lucky, you could find stuff.
So answer this question: what's the whole purpose of copyright law? Like we're talking so what's the purpose of copyright law? It's to protect a vested interest and create a barrier to market entry for those who have none.
Right. So I actually think about it as another way, that it recognizes economic value or some value in the copyrightable expression.
That can be traded.
That you can trade, that you can do
Right.
it, and it's worth something. And in fact, here's how you know it's worth a lot, is that, at least from what I've heard, and I want to hear back from the technologists, is that Meta and OpenAI and Microsoft, that they have such a huge start on any other startup because they have such a vast library of training information. And that Meta in particular, because Google and Meta and whatever, because they have all this data on our just daily habits, on our website usage, on our, whatever social media work and everything like that, all that can be fed into some sort of AI, a predictive model, to come up with a prediction on like what we're gonna spend money on, what ads to be shown to us, right? And they guard that data quite a bit. That's their trade secret. That's like, that's their big competitive advantage that locks out a startup that wants to do something in the AI space, right? So if all that training data is so valuable,
that's temporary. Like, we do not understand what training is. Like, we talk a lot about training because we think we're gonna trains a model, it's going to learn. But this training and learning is completely misunderstood. Because you take a 10-year-old, you explain to them something, they get it. You don't need to train them through gigabytes or terabytes of data. So today, that data, whatever, may be useful to create some model. But in some near future, we actually figure out what learning is. You don't need to explain it many times. So how does our argument stand up?
I think I could summarize that as that data is only valuable because our model training algorithms are so bad and need so much data.
But like I said, it currently is valuable. And so if it's
Well,
valuable.
I mean, you know, horses were a lot more valuable before we invented automobiles, so.
True.
So if we figure out that, hey, we can create a model that now does all of this.
Right, and if you don't need the New York Times' all their vast library of stuff to train your model, then yeah, the New York Times really can't sue you, or it doesn't have any point in suing you, right? But if you are literally using that to train your model at the current state of technology, and I think that this is my basic understanding, is that we don't really still have true general AI. We still do not, although isn't there some supposedly new reasoning model, like this Project Strawberry thing that's coming out, and that's supposedly...
Yeah, I would just say that, you know, unless there's something in a secret lab nobody knows about, I have not seen anything to indicate that it's not just a very impressive statistical model.
Okay.
And anybody who is like Yudkowsky catastrophizing on you that it's sentient and going to kill us all, it's like, no, it's more likely a human misusing it will kill us all. It doesn't know what it's doing.
But the point I guess I'm going to is that there's not been a technological breakthrough where something actually truly learns. It just gets more efficient at sorting through a vast library of training information to identify patterns and then apply those patterns when appropriate.
So Drew,
Likely, not appropriate. Appropriate, that's the part we don't have. It cannot give still correct answer. It can give a likely answer. And you can tell it cannot give you the right answer as long as they hallucinate. It's a statistical model that may take a different branch and completely tell something else. So they will not be correct until they hallucinate. And they hallucinate as long as they build statistical models.
and in fact, the best way to illustrate that it doesn't actually have understanding is ask it to solve simple addition problems, solves them no problem, because there's a ton of those in its training data.
Right.
Ask it to sum two enormously huge unique numbers, unlike your calculator, it'll get it wrong almost every time.
Yeah. So again,
That's
these
why
large...
strawberry is called strawberry, because you ask it how many hours in the word strawberry, it keeps miscalculating that. And the part of that, like, the machine learning models, they actually don't see words. They see tokens, which are...
And tokens aren't letters, they're...
And tokens aren't letters. You can't actually operate on the words that we see, because they're blind to that.
Yep.
So that's why, again, I sort of view the current level of technology as basically just a shortcut through a massive amount of training data.
It's not a shortcut, because shortcut is correct. That thing is a thing, it's going to be likely there.
Okay. Well, it's
Well,
a
it could be
predictive model.
incorrect if you have to go across a swamp filled with crocodiles.
It could be incorrect when you ask it how many hours in strawberry.
Of course, this is
It
also
may really
getting
be
back to
correct,
that many
yeah.
of the original sources on the internet are just wrong too. They're not necessarily any more reliable.
What's the best way to solve the problem? Put the wrong answer in someone come correct it.
But I guess, like I said, my view is because the current and again, I would love to hear if I'm wrong on this, that the current level of technology with generative AI is highly dependent on the training data.
That's correct.
It isn't true. It's literally lossy compression reconstituted, right? That's-
So actually,
What's
compression-
what?
In fact, people have even
Specifically
been
for
creating
term.
compression algorithms
Which is
using
a
large
thing
language
you
models
have.
actually. So yes, the comparison is very apt actually.
Compressive is a word defined as compressive, which means more than it sounds.
Well, lossy compression implies that there's loss, right? It's not, the fidelity is not.
I don't know enough, I just know enough that compression has a legal precedent to that.
Sure.
That's
That's literally the basis of a transformer model is essentially compression.
Yeah, it's compression of latent space.
Right.
So, sorry, explain lossy compression, because I was a literature major.
You can have lossless compression in audio CDs, for example, or other
Okay.
forms that can reconstitute the original perfectly, bit for bit, right? Or you can have lossy compression, which can achieve much greater rates of compression, but it's not going to be perfect when it comes back out and it is reconstituted.
it throws away a few bits of entropy because it can get it way smaller than if it didn't,
Okay, got it.
basically.
All right.
Yeah.
Well, do we want to keep talking more about the copyright issue? Because I've got a couple other topics that I...
Maybe we'll move on, though I don't know, I do have, let me ask one final question to you, just because I actually personally am interested in your answer, which is, what do you then see that, you talked about the economic value, which I hear that, but how is this different from the evergreen proposals we see periodically of solving the crisis in news with link taxes, which I hope everyone in this room is against and knows is a bad idea. So why are link taxes bad, but why is it potentially fair to pay for training data?
What's link taxes?
Link taxes is the idea that every time somebody links to your website using Google, Google should pay that website, basically, that you
So-
can freely share your tags.
So believe it or not, like, it's probably about as good of an idea as any, because here's the reason why. Like, even fundamentally buried into the concept of copyright law is we can't figure out what the appropriate price for information is, especially if you can endlessly replicate it at no cost, right? So how do you create a price for it? And believe it or not, there are really just arbitrary prices. So for example, if you stream a audio recording or whatever, there was some arbitrary, fraction of a cent that a committee came up with and decided, all right, well, every time you stream a song, we're going to charge 0.005 cents or something like that for it. It was kind of arbitrary. And again, you can come up with an arbitrary way of figuring out the value of something based on the number of links, which, for example, with respect to academic publications, that's a great way of determining the value of an article.
Oh, back ranking, like, literally Google's algorithm, how many times has this been cited? That's how valuable this paper is.
So like I said, in theory, it's actually not a bad idea, but again, that's a little bit off topic, I think, for
Well,
everybody.
yeah, and I'll say that, that definitely, I'm not a fan of link taxes, so that would be distracting, but I certainly could have a debate about that. But anyway, yes, let's on to the next thing.
Okay, I'll talk really briefly about an actual legal issue that I dealt with in employment law, which is dealing with confidentiality and trade secrets. Because again, a big legal concern that a lot of companies have is that any information that you put into Chat-GPT or any generative AI, number one, currently under the current technology, will go through a centralized server. So you're exposing confidential information to, Microsoft or OpenAI or whoever. But it's also being used to further train that AI. And when it comes to lawyers who deal with attorney-client confidential information, where we have an ethical duty not to share it, it becomes a big ethical no-no to put client confidential information into AI. And what's funny is that I actually dealt with a case of someone who got fired for putting in confidential information into AI of their employer. And I'm not going to reveal who my clients and what the situation is, but it's just funny how, literally, okay, yeah, that person did something really stupid, right? They literally got caught putting in confidential trade secret information into it was some competitor of Chat-GPT or whatever like that. And when they got caught, they thought, oh, there's nothing wrong with that, right? You just use Chat-GPT, you just use Chat-GPT. I'm using it and it's helping me do my job. And
They thought it's like they typed it into Word or something.
So anyway, it was kind of a little funny, sort of simple story, but that's, again, one of the bigger legal issues that lawyers have to deal with is that we can't use AI if we're involving confidential information.
Question, can lawyers use Gmail or some other alternative online email?
They do, and believe it or not, there was a large debate or question about it, but my understanding is that the current level of security is considered, keep something confidential.
So is it just a difference in service level agreements between ChatGPT and Gmail?
Well, ChatGPT explicitly says that if you're using it, it will put in the queries as part of its training data.
Yeah, I think the key difference being that Gmail in theory, now we know this isn't entirely true because it's Google, you gotta probably use something like Proton if you want more guarantees, but in theory, your email is sandboxed where nobody else is gonna get access to it. But if the thing you put into ChatGPT is fed into the training model, everyone has access to it implicitly as part of the model. That's how we've gotten these stories of like people having their medical x-rays spit out by these tools.
So you can get access to ChatGPT models through Microsoft, through Azure, and that kind of licensing agreement that your data does not propagate and is not used for training. So
Yeah,
is this a gap?
for that purposes.
Well, yeah, I mean, if, as I said, at bare minimum, I would check the licensing because, and a lot of the tools are starting to offer toggles of don't use this for training. And yeah, it's sort of the similar thing of like, well,
But it
you have
isn't-
to, right, well, that's the thing, it gets into you have to trust them, they may do it anyway, but at least in theory, if there's a contract, you
have a
could
report.
sue them if you could ever prove it that they did that.
Same with Gmail, like if Gmail links it somehow, hey, you told me you're not gonna use it, you did, you have a recourse.
Yeah, of course, this gets into why I'm a fan of like end-to-end encrypted services, because even if there is a contract, I still have to prove it to sue them, and good luck proving Microsoft did it,
So in theory, the future, of course, is going to be localized large language models. Like instead of sending something to Chat-GPT or whatever, X company is going to have their own home-built, home-hosted, internally hosted large language model that's specifically trained on its own data, and therefore, all the information, the company trade secrets stay entirely within it. And I think what's going to be interesting, again, particularly as an employment lawyer, is that if this information gets used, for example, for making employment decisions, if it gets used for making business strategy, business decisions, and you have lawsuits over that, right? Like, how do you figure out how that model was trained? I mean, again, that is one of those future questions that future lawyers are going to have to deal with, is discovery on large language models.
They're already using it for bond determination here in the county level. If you go in, there's a scoring sheet. Because I did a Public Information Act request and they shot me down.
That's always code for they're actually doing it when they shut the request down.
Right.
I can't tell you a fun fact about those city discussions about AI. One thing I'm very relieved about is there's already language in there saying that any use of AI tools in an evaluative purpose, like a manager asking ChatGPT, here's data on my employees, evaluate them, that is categorically forbidden in the regulations they're proposing.
So talk about some of the products, and I looked at these last fall, and they're more going to come online, where it invites you to load all your discovery. That discovers evidence. So you get evidence from the other side. You get videos, you get documents, you get emails, you say, I want to find out what's important. And Thomson Reuters has a product, I forgot the name of it, and a few other people developing products, where essentially they're inviting you to put sensitive, privileged information that you get that sometimes is subject to a protective order, let's say on the CPS case. Pictures of the kid being abused by the parents that you don't want out there. It's inviting you to send it, share it, so it can be analyzed, and then it says, here's what's important and here's what's not. But if you look at the terms and conditions of it, it clearly violates attorney-client privilege, and then it puts it on you.
Yeah. Like I said, attorneys have some challenges. But yeah, what were you saying?
So one issue that has come up is that if you were attempting to understand whether some model is, say, trained on copyrighted data, or there's some tort that you're pursuing relative to a model and you're in the discovery process, one of the big problems is that even the people who engineer some of these systems would say there are a lot of it's a black box.
Yeah, black box.
So Sam Altman from OpenAI would say that about some of what they've done. There's another technology people are using to solve the problem of what's going on in the hidden layers and what have you. It's called XAI, or explainable AI, that in theory would tell you what's inside the hidden layers and everything like this. So that's what people are working on. IBM, Zurich, I know.
So why isn't that mandatory?
Well,
It's not that good right now. So sometimes it's just giving you a number rather than a convincing English
You
language.
don't understand how it trains.
The
You can't make it explainable if you don't understand how it works.
The experimental name for these kind of models is CANS, which is short for like Kolmogorov. It was some 60s Russian mathematician, I forget. But basically, the rough idea, without trying to get too technical for the non-programmers in the room, is that you can almost think of large language models as like They have a bunch of knobs you can turn, except there's like millions of them, so knowing turning which knob makes what happen is really hard. The actually can tell you, if you're like, why did you give me this answer for this input? It can actually highlight the portions of the model and say like, well, I mainly answered like this because of this piece of the model. And so you can actually start zeroing in on, okay, it made a correlation between these two things for some reason, and that's why it thought this was the answer.
So can one AI system detect that speech, text, or photos is generated by a human or by another AI model?
There are some watermarking techniques for.
I know watermarking, I'm talking just the
Hypothetically, I mean, I'm probably like the least expert in this room, but like, I feel like the idea of being able to reliably detect whether or not a thing is generated just seems to me like fundamentally on a philosophical level wrong-headed, because a lot of these that operate on the premise like GANs or what is it? Adversarial networks, right? So you're in a sense you're almost having like two neural networks, one that's creating a fake and the other is trying to spot the fake. So as soon as you like come up with a technique to spot a fake, that just gets integrated into the neural network and trained to create better fakes.
I think remembering my statistics classes, I can generalize the problem more generally. This is an unsolvable problem in statistics called type 1 and type 2 errors, also known as false positives and misses. If you think about the problem the TSA has of finding things at the airport, basically if they get too aggressive in their searching, they'll start flagging stuff as bad that isn't. If they get too lax, they'll start missing things. And there's usually a sweet spot to like try to minimize both types of errors, but to literally eliminate one kind of error means you maximize causing the other one. So it's actually literally impossible to definitively say this text was or wasn't generated by an AI. You could be very statistically confident, but you could never say with certainty. I mean, I as a human being could write text that's me, but given that I've learned kind of what AI text sounds like, I could intentionally try to write in a way that would convince it, oh, this is an AI. I could say things like, as a large language model, or I could do bad high school English essay things of like, in conclusion, you know, because it loves to end paragraphs with that.
Well, that actually brings it
You can
into
go to the source and prove authenticity on the source generation. Right?
Yeah.
When you talk about the camera, they embed the signature into the
You
picture.
can have a combination of signature from the camera, proof it happened before a certain time, proof it happened
I had
after.
the exit file the other day that on the image. I know nobody has a product that I can look at an image and see where it's been modified, but the actual generation itself. They still have problems with the eyeballs in the background on image generation, right?
You're not looking at
Fix
the
that.
image picture, you're looking at the payload, and it has a signature, like a cryptographic signature to that.
Yeah.
You starting to talk about, hey, the eye is not exactly correct, you're trying to interpret the visual thing, that can be, like, it's a cat and mouse game, it's a game, and you figure out how to fake it. You have to have a signature that you have control how it was created, but if you took a snapshot of that, you lost the chain of provenance of that, you no longer can prove anything. You have to get the original thing.
So imagine watermarking everything generated by AI.
Mhm.
So there's a law, it's a felony if you don't do it. Imagine the enforceability of that. I mean, how would you?
Well, yeah, this is Drew and I were even sort of alluding before this talk, because I was raising it as, yes, much like how we have cryptographic signatures proving you're on the website you think you are, that you could do something for products that make media, like phones, and cryptographically signed, this hasn't been modified, this hasn't been made with AI. But, you know, all you have to do is, literally, Linux has a tool that you strip metadata out of a picture, and suddenly it's like, well, the metadata is not there, so you can't prove it's authentic, but you can't prove it's not either. And you actually start running into major concerns about privacy if you're suddenly saying media artifacts can't have to have metadata and can't be anonymous. Sometimes people, for safety reasons, want to get certain media artifacts out there without revealing where they took them, who they are, etc.
You don't need metadata for watermarking. You basically Fourier transform the image and you put a little signature in the frequency domain. The image itself contains the watermark, but it's like hidden to the human eye. It's detectable by math. You could say every model has to do this.
But then when AI is integrated, let's
So-
say that you let in Saudi Arabia.
Or it works for text if you have enough, like huge amounts of text.
To your point, and I can tell you with certainty, every major frontier organization, OpenAI, Anthropic, they're all working on several methods to essentially identify the source of basically engendered text content. And they're both implicit and explicit methods. For example, I know one of our local professors here at UT, Scott Aronson, is working on this with OpenAI to basically insert just simple letter spacing at certain frequencies, at certain positions that make it practically certain that you can identify.
Well, right, I've heard that like when it comes to picking the next most likely token, you can bias it to pick the second most likely token or the fifth most likely,
Right.
and you do it just enough, it still looks like a real sentence to a human, but it sounds out like a sore thumb in the analysis.
So once the cat is out of the bag, once you figure out what is the method for detecting, you can adjust.
Well, right, it's a red queen's race, and as soon as I know how you're gonna detect me, and especially with, yes, training models initially is immensely computationally expensive, but once they're trained, transfer learning is something anybody can do on a powerful laptop, basically, and so, really smart people are gonna start making their own self-hosted models, many already are, and they're not necessarily gonna put watermarks in, and so even if the big players are saying, yep, this is AI, here's the signature, you're gonna still have plenty of just ordinary nerds like me who it's like, there's no signature in the thing I just made with AI.
So for example, I know that the major AI platforms have guardrails programmed into them, right? But then, of course, when I understand, I don't know how common it is, but I know that there are large language models without the guardrails. And I don't know how common, because it seems to me that they would still need that underlying training data that's only acquired through very expensive, large databases.
Well, and
There are almost every major, even open source models, they all have some minimal guardrails and safety measures. It's open weight and open source, but at the end of the day, you can remove that through additional fine tuning with enough work. It's not easy, but you can, and it has been done. But you can. It's almost easier to jailbreak through other vectors to fine tune.
And I think similar to building a tool that can universally know if something's AI generated, I think that you have a similar problem with guardrails, that no matter how good you get, somebody clever could always figure out a way to say the right string of tokens that nudges it into the forbidden latent space, and it'll tell you the thing it's not supposed to tell you, basically. I've played around with it, and I know they keep getting better with the guardrails, but especially in the early days, some of the jailbreaks were hilariously comically easy. Anything it didn't want to tell me.
My grandmother telling me a story about how to make a bomb.
Or anything it didn't want to tell me, it's like, oh, this is flavor text for a role-playing game. Instantly tells me.
So in theory, though, there's got to be a way of combining West Coast code and East Coast code. In other words, having some sort of program that requires there to be watermarking or something like that, and then having a law that requires that watermarking not be tampered with or whatever. It's still going to be probably violated, but in theory, relatively infrequently.
Well, I think at least on the coding side, I think where you often get this encoding is essentially agreed upon standards, essentially, where it's like, you don't have to build a web server that is compliant with HTTP. Nobody's requiring you to do that. You could build your own web server that communicates with an entirely different standard and protocol. Good luck sending out packets that any other web server on the internet knows how to talk to. So I think technologically, as far as West Coast code, you'd have to build certain standards around how large language models tooling works that, you could go build your own, but no system would interface with you because you're violating the agreed upon standards. But then again, I'm only a web programmer who does cloud stuff, who has an interest in this stuff. I'm sure there's already, I can tell, smarter people in the room about this than me.
So for what it's worth, I think it would be incredibly difficult to actually implement because there's a broad spectrum of the degree to which you utilize language models. It could be as simple as rephrasing one sentence in an entire document, or it can be generating an entire document and everything in between. And so it's going to be very, very challenging, I think, to actually enforce this in any meaningful way.
Yeah.
But ultimately, the people who design and build them are going to have 99% of the control over the regulation that they succumb to. So soon as a watermark requirement or anything else in it that uniquely identifies it as being generated, or whatever the fines are, and the enforcement.
It could be.
The enforcement mechanism is going to be staffed and by former AI attorneys and executives is and so on and so forth.
I mean, to your point, exactly, like, you know, even though I really, you know, rah the rise of tools like the Fediverse and things like Mastodon, you know, the risk of like self-hosted servers is, all that illegal content that Section 230 protected websites from, well, at the same time though, now you're the website operator. And suddenly, if you're self-hosting a Mastodon server, you're taking on certain legal risks of what your users are doing that you weren't before, actually. There's already been at least one reported instance of some Mastodon server got actually raided by the feds because not of anything they were doing, but like some stuff some of their users were doing on the server, actually. They stole his hard drive that had it on it.
Is it Cesium?
I don't know.
Okay.
I mean,
What
it's
about
always
your
a good
first
guess,
idea?
but I don't know.
Just to throw this out there, we had last year a guy named Peter Wang talk. He was right where you were. And he co-founded Anaconda, which is the big scientific computing data science platform. It's open source. Millions of people use it. And one issue he highlighted was that one possibility here is that there's going to be a tiny number of like Oracle level AI companies that basically just dominate everything, including regulation. So there'd be 3 or 4 of them. But what he actually thinks is going to happen is more the opposite, that there's going to be ecosystems where there's people doing roll your own stuff. And you think that's the more likely course, but there's going to be millions and maybe even gigantic numbers, even for each of us as individuals, not having one agentic thing, but each of us would be an ecosystem unto ourselves. In that case, it's going to make regulatory capture a lot more interesting and hard potentially.
Well, the challenge is that it really AI only needs to be good enough to fool the eye, right? And like our eyes, like for a photo or video or whatever, yeah, if it got scrutinized by experts with technology and whatever, then you might be able to figure out it's a fake. But by that point, the damage is probably already done.
And as we've all seen online, you know, people usually, when somebody gets accused of something, very, very few people actually do the hard, diligent work of going through the evidence. Usually people evaluate who this person is in terms of their ideological factions, and they've already decided if they're guilty or innocent.
Well,
Juries do that too sometimes.
Yes.
well, again, that probably. Well, first of all, I wanted to give you a chance. Did you have a question?
So, 3 problems: hallucination and bias.
Mm-hmm.
Hallucination is basically, I don't understand, like you can just post-process and look for every case. If you don't find it, it's hallucination. So
Yeah, I don't know why that doesn't already do that, but yeah. But that's why hallucinations, I think, are a technical problem that will easily be solved at some point.
And you said made up evidence at the beginning. So what I thought you meant is like, oh, maybe all the citations are correct because of the post-processing, but then it makes up something in there, a fact that didn't exist.
Yeah, that's the big concern. Like I said, this is actually my last point of the talk, since I already went over an hour. But this is like where I really wanted to steer this, is that the problem with courts is that they're determining the guilt and innocent and the liberty of someone, right? And they're doing it the best they can, and they use evidence, and they have a jury, and they have the jury evaluate things. But the problem is, you can make up a photo. So, for example, if your claim is, hey, I didn't commit that murder because I have an alibi because I was at this bar on this other, this time. Here's a photo, taken of that time that, of course, has been made up. That's when you talk about fake, made-up evidence.
Of a guy holding a knife that has an extra index finger. Right.
It's clearly criminal, though, right, to fabricate evidence, right? That's
But
probably
people,
some charges.
especially in divorce cases, I see it all the time. So not only will they fabricate text, they'll get burner phones and then save the contact name as a phone number, and then screenshot it, and then show up in court and testify.
So,
I mean, nobody points to the phone.
there's been some fair points you've made as to
Yeah,
the
right.
difficulty in identifying, but it's still, with a sufficient amount of resources, quite easy to identify generative images. And what we're also talking about, I would say, well, there are some use cases that you described, but Photoshop and image manipulation has been around for quite a long time.
Yep.
And I think that's just as great a threat as any generative model, if not more so.
You get evidence sprung on you, like in a restraining order hearing, or you get it dropped on you at the last minute, and they say, sorry, I didn't give this to you. I mean, regardless if it's civil or criminal litigation. And the judge is like, all right, well, just go ahead, we want to get this trial done, because the judge has to get their itis, just like pilots, they want to land the airplane. They're not going to stop, give you 30 days to go fact check, everything you're looking at. In fact, I got 1.7 terabytes the other day in a federal trial on a Friday, 1.7 terabytes of phone calls. And they expected me to listen to it by Monday. I calculated it would have taken over 800 people to listen to all those calls.
Give me a call, I can help you out there.
Well, no, the thing is that when you get into the situation where the evidence collected by the police or in an industry trade secret case is so massive and you wind up with a discovery dump in the middle of the trial, it's just impossible for you to go in, because AI can't pick it up and tell you whether someone's being sarcastic or whether someone's telling you a joke.
You might be surprised.
Or,
You might be surprised.
You might be surprised, yeah.
are you sure?
Yeah.
Going back to the judge, you were talking about something about made up stuff or, elusive, but you also mentioned bias. So where does bias come in and how does,
Well, so
and especially from the defense side as opposed to prosecutorial side?
So the bigger concern that I think the courts, like I said, the judge who had that rule, he actually explained that from his view, it wasn't just the hallucinations and the made up stuff. It was also that there's some sort of bias that's built into the training module. And the great example I can give of that is that Google early on was trying to use AI to help decide who to hire, right? They were trying to figure it out. And of course what they did was they put in the bios of their great engineers, the people they've hired, and had them do it. And they quickly had to stop that because they were discriminating against women left and right. Because it turns out that if anybody attended a women's college, for example, boom, they were off the list. Because the early Google engineers, none of them went to a women's college, right? And so that's an example of how bias.
I understand what bias is a large language model. I understand where that plays into what I'm filing with the judge.
Because you are, again, if you use, well, actually, I'll give you a great example. Let's say, for example, that the large language model was trained mostly on a certain type of case. And it relied on certain types of law that did not apply to another situation. We'll take naval law, admiralty law, which is its own unique thing, and maybe when you were trying to apply that to, I don't know, some dispute over your pool, then the large language model has been biased by all those admiralty law cases, and even though it's not wrong in the sense that it's correctly reporting the law, that reasoning has been biased by too much admiralty law cases and not enough swimming pool cases.
And that's a real world thing?
I mean, his specific example, maybe not, but in general, yes, that would be.
I understand the problem with bias.
Yeah.
Like applying RICO to petty crime or something, which has happened.
So
Georgia likes the RICO statute.
Is that it? I thought it was Hayes County.
Or Hayes County, yeah, we'll talk about Hayes County over Stiff Mark.
So in my mind, though, there's actually an even worse problem than the fake evidence, and believe it or not, it's actually the not fake evidence, which is the problem is because it's become so easy to create fake evidence, people's initial response to things is going to be able to doubt evidence. And this is more of a problem in the criminal law world where prosecutors have to prove something beyond a reasonable doubt. But when criminal defense lawyers can say, well, Your Honor, there's a good, a decent possibility this evidence that they're relying on was AI generated or AI tampered with, right? And all you have to do is convince one juror to have some doubt in their mind and, rapist, murderer, whatever like that ends up going free. Like that's just an example of one extreme example, but it also goes into a bigger question of our whole society in that something so stupid as the size of a crowd, if you don't like something, you just simply say that it was fake, right? And the problem is there's going to be enough of a population that is going to believe that because they have a doubt on, they know the capability of faking information, that we have this culture of doubting what our eyes see. And that, I think, is actually a really scary place.
You know, I would say sometimes, like, when I'm being living a smartass, I just go like, well, you know, the world survived millennia before even photographs were invented, so maybe it just means we go back to before these technologies and trusting them as the truth. But then I go on the flip side, we've had so many stories and scientific studies showing how absolutely unreliable eyewitness testimony is, and that's what most people relied on before we invented photos, basically. So maybe it's really quite bad if we're going to go back to that standard of just, do I find you socially credible or not?
So like I said, I was trying to think about how a court's going to deal with it, right? Because you're going to have this evidence, and that evidence is going to make or break the case, right? If the evidence is accurate, one side wins. If it's false, the other side wins. And both sides are going to have opposing arguments of whether or not, because again, even if you've got a watermark, you can fake the watermark, right? Like, it's going to be a constant arms race to be able to, like, detect fakes or generate more, more accurate fakes or so forth. So what's going to happen? Judges do not have the capabilities of figuring that out. What they will end up relying upon is experts. And then the problem is the experts who have a financial incentive to argue, oh yeah, that watermark has a perfect whatever and cannot be replicated or whatever like that. And you're going to have another expert who has a financial motive to say, well, no, actually there's this technology or this other ways, there's these theoretical possibilities where you can use a quantum computer to generate that hash and whatever. I mean, it's going to go completely back and forth again as a battle of experts. And by the way, that makes lawsuits more expensive. Part of the reason why it's become, and this has actually got bigger implications for justice, it's very rare that cases go to trial because cases become more and more expensive to actually try. And so that's why now everybody settles and whatever like that, and that has a bad effect on justice for a whole society. Well, if literally trying to put somebody behind bars because they killed somebody, and now the state or whoever, the society has to spend millions of dollars on expensive experts to talk about the reliability of the evidence that's used to convict that person, that's the arms race. That's where the arms race in the courthouse is going to go.
If I didn't know better, it seems like you're sounding like, yet again, only the really deep-pocketed will get justice or escape justice.
How many rich people are on death row right now?
I don't know, actually. That's an interesting question.
Very much.
But I would suspect not a lot.
Which also goes to my point of exhibit number 1 is your client. The odds of you in murder getting convicted, almost I can predict it based on the race and sex of the defendant and the race and sex of the victim. You tell me that, I can tell you the probability of whether someone's going to walk or not.
That is sobering and depressing.
Still today, and it hasn't changed much.
So that's, again, part of the reason why I wanted to give this talk to some technologists, because like I said, in the area of law, we have some serious concerns. And I frankly don't know what the solution is.
Yeah, I have a question about that. You brought up the East Coast and the West Coast as these types, and there's something really deep in that that I'm picking up there. I don't know, let's just call it AI literacy, for lack of a better phrase. A lot of people go and they read an article or two, and now they know all about it. And, it takes a long time to become an attorney, and even longer to become a judge, I imagine. So you're spending your whole life doing that. Now, how the heck are you going to really, really understand how these new technologies work? And I'm thinking about how, there have been patent attorneys forever, right? And these are often people who are technologists to start with. Is that not true? And then they learn law afterward.
I mean, that even ties into one of the things that led to the founding of EFF, the bemoaning that very few of our lawmakers come from the technology sector, and so all of these politicians making these laws, regulating technology, do not have a dang clue how technology works.
And I can really see that being a tremendous issue at this point, that people who are in the whole legal system really don't deeply understand what's going on, and I don't know how that's going to be fixed. I'm so intrigued that you were Lawrence Lustig's researcher, and he asked a lot of really important questions way back when sort of the internet was. I don't think any of his questions really got answered though. So now the questions are even bigger still.
Well, one thing that was kind of interesting from his like career trajectory or whatever, he started, he was a law professor and whatever like that, and I think he, obviously talked a lot with technologists about, all right, let's try to fix this, find ways that we can use code to solve these problems. But I think he ended up concluding that that isn't going to work, that at the end of the day, East Coast code will trump West Coast code, because you can outlaw it, right? And so he actually got into politics, which is, I did not go very well. But he,
I gotta admire, he was literally like, I'm just gonna overturn Citizens United and then I'm resigning. That's my entire goal here.
I think something that you are picking up, or what you're reflecting on with Lessig's conclusion about East Coast law dominating, I think is similar to something that I've talked with Kevin about before, which is that especially it's true of this idea of how do we deal with providence or whatever, but going back to the problem of the copyright things, ultimately copyright is a human construct. It doesn't exist. It's not a natural feature of the universe. It's not something that we can it's not like you can say this is my property in the same way that you can say this is sodium or this is chloride or whatever. This is my property because we all in this room have agreed that y'all aren't gonna beat me up and take my phone. That ultimately, and then extending that out to larger and larger systems being what the state is, what government is, what social contract is. So I feel part of the problem with a lot of these conversations people have, especially around the copyright stuff, is people are trying to find technical solutions to something that's fundamentally not technical. It's a human issue. It's ultimately going to be based on agreements that humans make between each other. I don't think there is a technical solution to that.
Well, copyright is generally just a substitution of a stone or other threat of violence used to exert control.
Right, exactly.
Probably just more civil way of.
Right, and part of the problem of trying to enforce copyright with these, models is that it's trying to get rid of piracy. I don't know if y'all know, piracy still happens. And it's not going away, it hasn't gone away. Netflix took a dent out of people doing it.
Well, and if they keep raising their prices, privacy's gonna get more and more popular again.
Yeah, which is to say that ultimately, if you're going to do, if you want to eliminate piracy, you can't eliminate it by just saying it's illegal. It's just the structure, the way that our internet works, the way the level of draconian surveillance required to actually enforce copyright law. The vast majority of stuff that you go online is probably violating copyright.
Actually, Ed even got into that there's all sorts of interesting licenses most people agree to just visiting the website. They're not even aware is going on, actually.
Many artists who object to their works being used to train models already agreed to have their works used to train those models. And also, Adobe literally owns all their data set that they use to train their model Firefly. So, these problems that people are having about copyright, and I think it's also true of these other problems, are fundamentally human problems, and trying to find a technical solution to them is I think misled.
So judges for hundreds of years, to your point about what do you do to a judge that knows nothing about AI, and they just read something in the bar journal that you wrote about it. So for hundreds of years, they used what's called an amicus brief, an amicus attorney, someone who's an expert in that area. And a lot of times we'll rely on the government to produce that, but because of the Chevron deference rule that the Supreme Court has completely gutted, essentially meaning that Congress creates a law and then an administrative agency is going to create rules because that's half the room in here to get hired to go create the AI cabinet position, and we're going to do everything in the regulations. None of that because y'all understand that. And the politicians who get put into the White House and Congress don't understand it. So the courts defer to the agency because that's where the experts are on pollution, on AI, on aviation, whatnot, because you can't learn everything. Voltaire's bastard problem. Well, with the Chevron deference rule now gutted, Congress is going to have to make all these rules, which you're not going to be able to do because thousands of pages of bills that no one
and because they can't, and these laws are ambiguous, ultimately judges will now be deciding instead of the regulatory agencies whether net neutrality is under Title I or Title II of the Telecommunications Act.
Right. So you take that for example, but I think I can count on one hand the number of federal and state judges that actually know what metadata is and isn't most importantly, and why I need it to prove that something was done or wasn't done or was modified or was saved as or was processed.
You're telling me I'd say the word timestamp and be depressed how few of them know what that is?
Well, sure. And it's getting a little bit better because some of them are younger than I am, but even then, you do what the Rand Corporation did when they wanted to figure out a way to get judges to award personal injury plaintiffs less money. They started hosting lunches, bringing the judges in and talking about economic theory, nothing about plaintiffs and injury, but economic theory and how to calculate damages. And after that, their awards from the bench started going down. So you could do the same thing, which I guess you're doing with Pittman, right? Yeah, so Pittman's one of them that actually understands it. When I say, the DEA didn't give me the metadata on this photo or this video, he'll just snap his fingers and the next day it shows up. Because they literally will print the photo and then scan it and then send it to me.
So the funny thing
I'm
about
not kidding. They print it, scan it, and then send it to me.
Well, given
Or
how much
print it,
of the
sell it.
state ledge still literally is using barcodes and scanners, I believe this.
Just to tell a quick funny, well, now I don't know.
Is that on purpose about giving you metadata in the first place?
Oh, yeah.
Print and scan.
Well, because they know that I can like go through and find something wrong with it.
Yeah.
So they changed it. It's not
It goes back. It's not a technical problem, it's a human problem.
Well, it's a cheating problem,
Yeah.
and it's a parity problem, or it's a an equity problem. That they have more resources than I do, but I still wind up kicking their asses anyway.
So, not a cryptographer at all, but to answer your earlier point a little more directly, literally, technologically, there are actually means to authenticate video and digital media content if the original system has the infrastructure in place. There's cryptographic like fingerprinting and verification and hashing that you actually can use to with the same amount of certainty as you have in that encryption standard, which is pretty darn high. The ability to actually verify the authenticity of a
But it seems to me that there's an arms race where you could devise a system that would defeat those cryptographic.
Not the encryption yet.
Not really.
Not in your future.
I mean, not the encryption itself, a flawed implementation of the encryption where the code is buggy, sure, but the actual math, no.
And you end up with something akin to what is basically filling the role that a bank does for money, right? Kind of intermediating these sorts of disputes by actually keeping a record of these hashes and these different signatures and making sure that they're ascribed properly, so that you can go back to these sources and they can kind of say, okay, I've got the receipts to say that this hash is correct, hasn't been messed with, it actually does apply to this piece of data and all of that.
Yeah, which is a social human trust system,
Yeah.
right? Like we trust the bank to not, to be keeping accounts.
It's similar with when you visit a website, your browser has the little lock, a little shield saying it's all safe and authentic. That's all ultimately a system girded by what are called certificate authorities, which is basically some fancy cryptographic math, but it's basically a company who keeps a registry of website names and legal entities who own those website names, and they basically are checking data you got from that website with their database and basically saying, yep, you're talking to the real guy who's allowed to claim that they're this website, basically. But it's built on a system of trust. There have even been scandals where certain certificate authorities started getting lax about who they were registering, to the point ICANN's occasionally even kicked certain certificate authorities out of the trust scheme. Actually, there was a recent certificate authority that Mozilla and Chrome and Firefox started being like, no, we won't actually check that in one from that one anymore. We won't say it's safe.
That's a significantly high bar on authenticity. Like you can really check if there's a certificate actually corresponds to that. And we're using kind of similar terms, so like different terms for similar things. There are certificates and hashes, they're a much higher bar. And another term we mentioned is a watermark. Watermark is a much weaker mechanism than the hashes and certificates. So you can have a photo that comes along to the payload, you don't look at any pixels visually. It comes back with a certificate or hash, and you can't really fake that. Like if you have that hash, that guarantees it came from there.
Right.
You can lose it and now you don't know where it came from. You can lose, it's much easier to lose the watermark. Like you print and scan it. Not many watermarks will survive the print and scan. There are some that are designed for that.
Even a simple, like, tiny crop can destroy the watermark, depending on how it's done.
Well, just very quick technology question. I assume that the most common formats for images and video do not have this cryptographic or hash, security built into it.
You can.
They can, yeah. Like, I work for a video surveillance company,
Yeah.
and pretty much any video that you want to secure, you put an MD5 hash on it.
Yep.
That's it.
MD5 is kind of the industry standard for this sort of thing.
But of course, most cell phones, most video cameras don't have this.
Right.
It is specialized systems like video surveillance.
Yeah. So that's
So that's for
kind of-
visibility purposes, the reason they want that, so they can use it in court, exactly
Yeah.
what happened and not.
It's not a very good security cam if you can't verify its authenticity for a lot of the reasons we've just been discussing.
All right, well, it's already after 8:30, so I wanted to make sure we had enough time to.
Do
go
we have
get a drink
any
or
burning
whatever.
questions for Drew nobody has gotten yet? I guess, because he did come up so much, I will just leave for everybody that actually, Lawrence Lessig actually recently put out a TED Talk on AI. I actually don't agree with everything he says in it, but I still recommend you watch it because he raises some interesting ideas about AI. I think everybody in this room might be intrigued by it. But any final questions for Drew before anybody who's interested goes and gets a drink with us?
I'm just gonna have an idea, I'll just throw it your way and see what you think of it. So, a lot of different countries and cultures are dealing with this right now. Some of whom have, in the Anglosphere, have a very similar body of law because we inherited a lot of ours from theirs. And then there are other Scandinavian countries with different norms. But there's a lot of people dealing with these issues. And I just wonder whether best practices that are coming from some of the higher trust countries, where people are, say, less cynical, like the thing that you're identifying about people doubting real evidence because they're just doubting in general and they just become postmodernists, whether they know that or not. Like, I wonder about countries that are very low corruption, very high trust, how they might kind of do some sense making about what are the best practices to deal with this kind of thing. I mean, I think to add on other people's point, technology will solve some of this stuff, but some of it will not be solved by technology. It's cultural. So I don't know, do you know anyone who's kind of thinking about this stuff? Are there thought leaders on the continent, the European continent, or some other place that you would have identified as like some of the people who are really working on this and putting out some good sense making?
I haven't, again, I'm not obviously an expert in other languages, and there might be some research and discussions going on in other countries or whatever, but given that OpenAI is a US company, and Google, and that Microsoft and everything, it seems to me that a lot of the discussion, whatever, the cutting edge seems to be mostly here. And I also think that, again, places like China, they're going to have like some sort of just outright ban of things if they don't want. They have that more of a power to do that. And so I think that...
Unless you're Uyghur.
I just think that we can't, I don't know if other, just general principles or anybody who's like applying those principles to AI. That would be kind of, but it is kind of interesting how you're probably right that other cultures have like just a different basic philosophy towards things, whether it's the difference, for example, between common law and civil law, like within the world, that there may be a completely different view that I'm just not educated about.
I mean, I guess anecdotally I can pass along that, once again, protecting his privacy, but some of you may know who I'm talking about. There's somebody who attends our meetups sometimes who, he's ultimately from kind of a Slavic cultural background, and because of that kind of Soviet, post-Soviet, like, he often has, although very intelligently argued, often very different takes on what I do on privacy, and when I really kind of drilled into why, a lot of it just boils down to, he's like, of course they're spying on you. They spy on you at all times, and there's nothing you can do about it. Why are you wasting so much energy worrying about this? So I suspect, yes, there's probably some fruit in what you're asking about. How, if AI is ultimately a human problem, well, then we maybe should be thinking about a more global perspective, because we may not all have the same human problems that will affect how we interface with AI.
We're all trained on different data.
All right, well, I said let's give Drew a very good round of applause. But yeah, we're going to go get a drink. Oh, yes, if you parked in the garage and need a voucher, the person at the front desk should have them, but actually, I'll be right back and get a few for anybody who needs some. But yeah, we're going to go over to the bar if anybody would like to join us. We hope we'll see you next month.
Who's going to show me that can detect sarcasm?
Also, you'd be surprised. Yeah, within the last 3 or 4 months. It's
How is it? Yeah.
not just dad jokes, but actual
It's all very nice, thanks. Especially when we got to hear you. Appreciate it.
I think it was appropriate because he, so here's the thing, I actually traveled down to the
They're alone.
I can confirm, so there's a bunch, and I even have ChatGPT, it's called ChatGPT, monitored by extracting down.
One of those faces like this.
Dorian Albert collection.
Well, very nice to meet you.
Like
He
what?
did design push card machines
Harris?
and small textiles.
Very small.
Which is interesting, because they're, Right, yes, right. But it's also, because, yeah, that was,